Good afternoon, and may it please the court. My name is Sergio Ardila, and I represent claimant appellant in this case.
I knew this was going to be different based on her recollection of the events.
A very important case where I was hurt and justice was done.
There was poetic justice there in that she changed the law, helped change the law, and ultimately she was able to fairly resolve her case.
Justice will be done if you do the right thing. I fell at my job and it was pretty serious for me. It progressively got worse and worse. They sent me to a doctor that it wasn't my choice, and I should have been my choice, and I did not know because I've never done anything like that. So I decided to call a lawyer.
When I first got the Linda Lilienthal case, she was about 3 months from her injury. She had really not been receiving adequate treatment at the time. She suffered bilateral knee injuries as well as a shoulder injury, and it seemed like she had only been seen for the shoulder, despite the medical records mentioning the knee, and then Linda telling me that the knees were the most symptomatic parts. In workers' comp, something that's peculiar about that practice of law is oftentimes you see downright abuses of the law, both by the insurance companies, their attorneys, sometimes even the judges, and the whole adjudicatory system. Many times you get some settlement offers in light of these abuses of law and power that the settlement offers make sense for the claimant, my client in these cases, to accept the money. Despite that, this was such an abuse of the law that this case in and of itself stood out to me as one that was likely not going to end up in an amicable settlement from the get-go. In this case, the insurance company and the employer blatantly violated one of the few solid workers' comp statutes.
This case is about the employer failing to meet its obligation under this crystal clear statute and the failure of the judges below to uphold the statute and instead rewriting the law to get around it. The statute provides, and I quote, "The employer shall post the panel of physicians in prominent places upon the business premises."
In more layman's terms, there's a statute that tells the employer that it must keep this list of doctors that we discussed, and it must keep it posted prominently within the business. Now, prominently is not as precise as let's say, has to be kept on a 6x10 wall on the left side of the business, for example. So even though prominently is pretty clear, it's not as precise as, let's just say, different descriptions of where it must be kept. When I first get a client, I spend about an hour trying to make sure that I understand all the facts of the case before I do anything with it. And she mentioned that there was this list of doctors, but the location of where the list of doctors was kept didn't seem like it fit within the statute.
The facts are not in dispute. The only location where the employer ever kept its only panel was in a locked room with the lights off, with the only key to it being in a closed metal box, in a closed drawer, in a desk used by administration.
Another thing that was also a blatant violation of the law is that once those facts came out, and I say came out because at the beginning it's mostly an allegation. I get the case, I request a hearing, I send some discovery, and I might speak with the insurance company, whether it's the adjuster or their attorneys, and tell them, hey, from what I understand, this is where the list was kept. Now, when I say it came out, I mean claimant had already testified that the list was kept in this locked room, and they had verified that with the employer. But this case was different because the insurance company still took a stance that even though it had been verified that this list was kept in this locked room, they were still going to double down on their defense and say that that was okay, even in light of the statute clearly telling them that the list of doctors, which we call a panel, must be kept in prominent places within the business premises. That's the word that I was arguing. And it seemed like I had to keep bringing this to different judges because the judges would not address the simple issue of the case, which was, did the employer post this list of doctors in a prominent place upon the business premises? The judges kept dancing around this clearly worded statute just to fine for the employer. And that is what shows you the bias that this whole legal system of workers' comp in Georgia has. Because when you bring a simple issue, which is, here's the statute, here are the facts, do these facts show that the employer in this case follow the statute or not? That's the answer that you want. Yes or no. Not, is there another way that we can rule in favor of the employer insurer?
We are here because the issue of whether the employer posted its panel in prominent places upon the business premises has not been decided. The state board failed to rule whether posting its panel in this locked room with the lights off was posted in a prominent place, but instead came up with a separate test, ignoring the literal shall post requirement and instead ruling and analyzing whether the claimant had some access to the panel.
From the beginning, it started where I was hopeful, and then it got kind of discouraging because of them saying, me losing the case at first and then going on, and I kept thinking, will it ever end? But it went on, and I kept praying. I was still working, and it was hard for me to work, and it was getting progressively worse. My knees were really hurting.
It was a long process, and she had a lot of setbacks, and I started giving up because it was like she went to the first court, lost, second court, lost.
That's another thing that was different about this case. You would think that either you were going to settle the case before trying it, or you were simply going to try the case, show the judge the facts, and have the judge analyze that the facts show that the employer-insurer violated the statute. But no, surprisingly, the judge said that even though it was kept in this locked room, it still fit within the statute because, according to the judge, the claimant still had some access to the list of doctors.
We're not looking at whether the employee could have followed some carefully crafted set of steps that might eventually lead her to unlocking this door and getting access to the panel. The statute is clear that courts should look at where the employer posted its panel, and there is simply no law directing us to look elsewhere.
In total, it was 5 judges that simply did not want to address my issue at all. And I had to take this all the way to the Court of Appeals, the Georgia Court of Appeals, simply to get a judge or some judges to address one legal question.
Conversation was, don't give up hope. We have hope. We were appealing, and we're working hard on it, and we're going to go further and not to give up.
I felt confident simply because I knew the law was on our side. And when we finally got a fair shake with impartial judges and judges that actually cared about the system as a whole and the parties to the system following the law, I knew that eventually the choice would only be the correct one, because it was pretty clear to us and to anybody else that wasn't biased. They finally ruled in favor of claimant. And again, this wasn't a complicated issue. The Georgia Court of Appeals looked at the statute and looked at the facts. The Georgia Court of Appeals finally analyzed and addressed that legal issue for us. It ruled that the initial judge had never made that analysis. The Georgia Court of Appeals sent it back and said, hey, you need to analyze the legal issue here. This is what the statute says. Make the analysis whether the facts fit within the statute or not.
When he told me we won, it was just like, wow, I couldn't believe it. I was very happy about that. We won, and I was like, I couldn't believe it that I was hearing what I heard. I said, really, it can't be, finally, but it can't be, but that was a very good day. You did for all of us.
The last time that when I saw he went to the Supreme Court and I saw the case, I knew he won.
Yeah.
Because
that's why you have to
it was
travel.
good. The judge in the Supreme Court was questioning Sergio, and he had every answer. And then when he questioned the insurance lawyer, she was mumbling and stumbling, and he was asking direct questions, and she didn't have an answer.
That was the most memorable time. I called my client and I explained, hey, we won. At that point, I had already called her 3 other times telling her we'd lost. So this was the first time, hey, we actually won, and it was by the Georgia Court of Appeals. It's very likely that there's not going to be a higher court to look at this, and it's very likely that this is going to be the decision that's going to stick. How did I feel? I mean, I had been arguing the same thing for years, and I kept losing in the lower courts. And I just thought that I really wasn't asking for much. I really just wanted somebody reasonable to look at the statute and look at the facts. So I felt, in a way, everything was rectified when the Georgia Court of Appeals finally analyzed the issue that I had been asking, at this point, 4 courts to analyze, and the 3 initial courts had simply refused to do so. I felt rectified, I felt vindicated. But more than anything, I was just happy for my client. She has very serious injuries, and because of this, she hadn't really been able to adequately treat her injuries. And after we won in front of the Georgia Court of Appeals, it seemed like she was finally going to be able to do so.
I felt relieved because I know that eventually I would get my medical that I needed for my legs, and I knew it was going to be taken care of. That I wasn't going to be, in that much pain. I mean, I'm getting it done soon, so I knew there was going to be a closure, and I was so happy about the closure.
The law in itself wasn't changed. And again, we didn't want to change the law. The law was clear. It did change some things that the defense bar, the insurance companies were trying to push. They were trying to push things like e-panels, which hasn't been really stated in any statute. But slowly, attorneys sometimes either expand laws or erode laws. And in this case, they were trying to push to allow employers to get away without following the law. So this strengthened and solidified that statute, which again just states, post this list of doctors somewhere on the business premises that is prominently displayed. Pretty clear. We're not doing an e-panel. We're not doing something where you maybe get on your phone because you might not have a phone. You know, you might not have a smartphone. You might not be able to do that. The list of doctors has to be posted prominently on the business premises so that anybody who works for the employer can simply go look at it, whether they have a workers' comp accident or not. So a lot of times, once you do have the workers' comp accident, you might not be thinking straight. You are injured. But if you see it somewhere prominently posted every day, then when you do get hurt, you're going to remember that, oh, that's right, there is that list of doctors there. Let me go see which doctor I can pick from the list. I mean, the employer insurer already get to pre-select 6 doctors that they decided might benefit them and look out for their interests. The least you can do is follow the statute so that the employer can at least look at the list and try to make the best selection from those 6 doctors. This was a mixture of facts and the individual positions that the employer insurer took that led this case to have some type of poetic justice at the end. Many times, claimants, such as my client, have to take a lower settlement offer. And when I say lower, I mean lower than a just and then a fair settlement offer, simply because of the facts of the case. And that happens sometimes because the claimant has to weigh whether it's worth going to court and potentially losing, or get a lower than just settlement and not have to run that risk. Because of that, many claimants end up taking lower settlements. There was poetic justice in this case in that they never offered her a single dollar before this case ultimately was lost by them. There was so much misplaced confidence by the employer insurer that they still didn't want to settle the case, even when they could have settled it for a lot lesser value. There was no settlement offers coming out of them throughout the entirety of this process. What's important about this case is because of that position that they took, she ended up not only further specifying the law in Georgia, and now her name will always be tied to an important case in Georgia, specific issue of the panel of physicians, but she was also able to get a much higher compensation because of that, if they would have done what I believe was the smart thing to do and offer something during the entirety of that process where she kept losing.
Definitely tell someone to go all the way. All the way. It's worth going all the way. Don't just settle or just walk away from something or let people talk you into that it's not a good idea.
It's hard. It takes a long time, but luckily the truth came out, because if he didn't win the final thing, she would have lost. I mean, she should have won from the beginning. They never helped us out. The insurance companies never helped you out. They're always against you, and it's disheartening.
I would definitely use him again or recommend Sergio and his team for any kind of, I have already recommended him, and I would recommend him, because he did a great job and he's really into it. I mean, he is one of the lawyers that doesn't care, he cares. I think he did great. Definitely. He did a great job.